CR 3050B, State of Texas versus Richard Reyes. Can I have parties announced for the record for the state?
Jason Gearhead, Your Honor.
Defense,
Nick Aguilar on behalf of Richard Reyes.
are you Mr. Reyes?
Yes, ma'am.
Showing you what's entitled application for deferred adjudication or community supervision. Well, you're only eligible for deferred. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Next, I'm going to show you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
All right. Did you understand you're charged with the offense of aggravated assault with a deadly weapon? That is a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
We're finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
We would ask if you would consider that, Judge.
All right, Mr. Reyes, what is your problem?
Your Honor, I just had a really bad year and some people pointed guns at me and I thought it was them.
And it turns out
And that it wasn't them.
it wasn't them.
Ma'am.
See what happens when people want to be a vigilante? You don't know if it's the correct person or not. This could have went south so quickly. You understand?
Yes, Your Honor.
So how old are you?
22.
You should know better. And then taking your girlfriend with you?
No mistake.
One, why would you take her with you? For backup?
All right, guys, buckle up because this courtroom session opens with a serious felony case that immediately sets a strict and formal tone. Richard Reyes is standing before the court on an aggravated assault with a deadly weapon charge, and from the very first moments, the judge ensures every legal document is acknowledged and understood. There's no rushing here. Every waiver, indictment, and admonishment is carefully confirmed on record. But things shift when the judge starts digging into the circumstances behind the offense. Reyes explains it as a chaotic situation where he believed he was targeting the right individuals after a stressful year, but the judge doesn't soften the reality of it. The courtroom quickly becomes a space of accountability, as the judge points out how dangerous mistaken identity and vigilante behavior can be. What stands out is the firm reminder that decisions made in seconds can permanently alter multiple lives, especially in cases involving firearms and fear-driven reactions. Even early on, it's clear this isn't just about paperwork. It's about judgment, consequences, and control over impulse.
The court is finding there is sufficient evidence to find you guilty of count 1, count 2, count 3. Court will defer finding of guilt as you apply for deferred adjudication. Going to set your deferred adjudication at 10 years. And counsel, if he completes everything,
Yes, Your
you
Honor.
can come back.
We've explained that to him.
All right. So that'll be 10 years deferred adjudication. There's a $1,500 fine. That will be probated. Count 1, count 2, and count 3 are running concurrently. Take in consideration 2023 CR 3051A 700-200 677-351. There's to be restitution, if any, and no contact with. And counsel, if the restitution you feels like it's not the correct amount, we can have a restitution hearing.
Absolutely, Judge. Thank
And
you.
that will be with Jose Casares, Miguel Rosas, Ashley Almeida. We're going to do regular UAs, test for levels, proof of employment within 30 days, no employment as a home health care provider or with minors, regular reporting by Zoom or in person.
Because this part of the hearing dives deeper into the defendant's mindset and personal background. The judge moves beyond the crime itself and starts questioning his life situation, including his job, family support, and behavior leading up to the offense. Reyes mentions working as a catering assistant, transporting food to events, but the conversation quickly shifts again when drug use enters the discussion. He admits to using marijuana, trying to justify it as pain relief after a back injury and limited access to medication. However, the court makes it crystal clear that probation conditions leave no room for substance use. The judge carefully listens but keeps redirecting the focus toward responsibility and compliance. This section highlights a key theme in courtroom decision-making. It's not just what happened during the crime, but whether the defendant can follow strict rules moving forward. Even family support is briefly explored, showing the court is evaluating stability, not just punishment. Every answer feeds into the bigger question of whether rehabilitation is realistic here.
Anger management. 150 hours of community service restitution. Field visits. 1 time per month for 3 months. Probation, if there's no issue after the 3rd month, then you can schedule field visits that you deem necessary. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
No, Your Honor.
No. And I'm sorry, and there's an affirmative finding of deadly weapon. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. You're gonna have to make better decisions. You know, one bad decision can ruin your life. All right, good luck to you. Stay in the courtroom. Probation will go over conditions.
Sure, Your Honor.
This is where the sentencing begins to take full shape and the weight of the decision becomes clear. The court finds sufficient evidence on multiple counts and moves forward with deferred adjudication, placing Reyes on a 10-year probation term. That alone signals long-term supervision rather than a quick resolution. But it doesn't stop there. Fines, concurrent sentencing structure, and restitution all come into play, building a strict legal framework around his future. The judge then outlines extensive probation conditions, including regular drug testing, employment verification, restrictions on working with minors, mandatory reporting, anger management, and community service hours. Field visits are also added, showing that supervision will extend beyond paperwork into real-world monitoring. There's also an affirmative finding involving a deadly weapon, which significantly increases the seriousness of the case. The tone throughout is firm but instructive, making it clear the court is not only punishing but actively attempting to prevent future violations through structured control and accountability.
All right, that was silly. Do you have any children?
No.
That's good, because you're not ready for them right now. You understand?
Yes.
All right, are you still with your girlfriend?
Yes.
Do you have any children? Are you employed?
Yes.
All right, what do you do?
I'm a caterer, assistant manager. I take like the food to the events like weddings and like balls, you know.
All right, you
that-
piqued my interest when you said caterer. I thought maybe you were cooking and I was about to ask you some food things, but okay,
I just take
Sounds like he's a transporter.
yeah, okay.
I just manage the event, you know, with the food.
All right, do people ever taste food and don't tell people they've tasted it? Your attorney probably doesn't want you to answer that question. People are always like, did the driver take one of my fries? I don't know. Oh, you did, okay, Mick. All right, so are there gonna be any drug issues with you if you're tested today? No, we can test you today.
Well, I smoked marijuana and that stays in your system for a very long time, sir, for ma'am. And I want to be honest with you. And one of my things is not to drink alcohol, so I haven't been drinking alcohol.
All right, so why are you using marijuana?
Well, my back, when this incident had happened, I was very hurt in the very beginning when I had got out of jail because when I was in there, they wouldn't give me like medication for like once a day and they didn't give it to me all the time. So when I got out, I went to the hospital and they said my back was hurt and I couldn't afford medication response.
All right, so you can't use marijuana while you're on probation in this court, you understand?
Yes, ma'am.
All right, where are your parents? Are they a support system for you or no?
Yes, sir. Thereabouts.
All right. This is what the court is going to do.
The hearing wraps up with a final reminder from the judge that carries more weight than the sentence itself. Reyes is told clearly that one bad decision can destroy an entire future, especially when probation is involved. The court emphasizes that compliance is not optional. It is the only path to avoiding harsher consequences down the line. With appeal rights waived and conditions handed over to probation supervision, the case transitions from courtroom judgment to long-term monitoring. The judge's final words reflect a mix of warning and guidance, reinforcing that probation is a second chance, not a free pass. The message is simple but powerful. Discipline, honesty, and responsibility will determine what happens next, not excuses.